Hey everyone, in this video, I'm going to break down the two easy divorce types in Illinois. Let's dive in. The first one is the agreed divorce. The agreed divorce is where you and your spouse agree on everything that's required to get divorced, on all the different issues that there are that you have to agree on to get divorced in Illinois. So if you have kids, you're going to have to agree on the specific schedule that you have the kids and your spouse has the kids, the holiday time, the summer parenting time, all of that stuff. And the decision making authority. So, who has decision making authority on the issues of education, religion, extracurriculars, and medical decisions? Most agreed divorces, that's going to be joint decision making. Now, in regards to the other issues, you have to agree on the how you're going to split the property and how you're going to split the debt, whether or not there's going to be any alimony in the case, or maintenance as it's legally called, and possibly child support. In many agreed divorces, if you're keeping things as simple as possible and you just say, we just want a divorce, we haven't been together for a long time, or we both agree, it's probably either going to be a you take yours, I'll take mine type of divorce. So that is where you're going to keep everything in your name. Your spouse is keeping everything in their name. You guys don't have any joint assets. Or it's going to be a split down the middle divorce, which is where you're saying, okay, we have this joint account. We're going to just split that down the middle. We own a house. We're going to sell it and split the equity. So usually a simple agreed divorce is going to be one of those two things. Now let's talk about what actually has to happen to get the divorce done. What has to happen is let's start at the end. The final document that you're going to have is called a marital settlement agreement, or MSA. That's marital settlement agreement. And that MSA, and if you have kids, you're also going to have an allocation judgment. That's allocation judgment. And that's going to include all the custody sorts of issues. Now, what do you actually need to do with the MSA and the allocation judgment? Well, these are the two documents that are going to have all the terms that talk about what we just that talk about what we just talked about. The parenting schedule, how you're splitting the debts, how you're splitting the property, all of that stuff. So, you're going to sign it, your spouse is going to sign it, and then you're 95% of the way done at that point. In order to actually get divorced, what needs to happen is that these two documents plus one more document, which is called a judgment for dissolution of marriage, needs to be signed by the judge. So, how do you actually get this in front of the judge for signature? Well, you have to file what's called the petition for dissolution of marriage. Filing the petition of dissolution of marriage is going to do two major things. It's going to give you a case number, and it's going to give you a judge. Now, once you have a case number and a judge, you can schedule your final court date. Different judges do it in different ways. So this is really kind of where the devil's in the details. Once you get your judge, there's going to be a specific way that you schedule the final court date. The Typically, the way that's going to be done is through a prove up hearing. A prove up hearing is where you go in front of the judge, you present to the judge the signed documents, and the judge reviews those, make sure that you have checked all the other procedural boxes. There's some other things that you do have to do here. For example, in an agreed divorce, one of the most important things that has to be done is that the opposing party has to file what's called an appearance. An appearance is a special legal document. It's not a physical appearance. It's a special legal document that says, hello, court. I'm here. I'm participating. I am submitting myself to the jurisdiction of the court. So that means submitting yourself to the jurisdiction of the court means that the court has power over you. You're saying, I am going to abide by these court orders. Uh, uh, I am honoring these court orders and they are going to be valid. So once your spouse files that appearance, which is a very routine matter if it's an agreed divorce, once they filed that appearance, then they also have to get notice of the prove up hearing. Those are the two big things. They have to get an official notice that you are going in front of the judge to finalize the divorce. If they've done those two things, then you've done like 99% of what is required to get divorced. Depending on the judge, there might be some other requirements. The other big one is if you have kids, you're going to have to take a parenting class. And your spouse is going to have to take a parenting class as well. This is usually an online class. It's like 4 or 5 hours. And it's not difficult. It's just a matter of taking the time to do it. So you'll finish the class, you'll get a certificate, and that'll also be presented to the judge. If you've done all that, you get in front of the judge is satisfied that you've checked all those boxes, crossed your T's, dotted your I's, then the judge will review your documents, will ask you some basic questions, or your attorney will ask you some basic questions, and you will be declared divorced. The judge will sign the judgment. You'll get that signed judgment back in a matter of days, and you are divorced once the judge signs the judgment. So that's the simple agreed divorce. Now, the other, let me see if I can get a new page here. The other simple divorce is called a default divorce. A default is generally the recommended or the best option in cases where you know the other side is not going to cooperate. They're going to ignore the documents that you send them. They're going to ignore your request for them to sign anything. At that point, you don't really have any choice if you want the divorce to move forward. You have to go ahead and move it forward. And the way you do that is what we already discussed. You're going to file that petition for dissolution of marriage. That's going to give you the case number. That's going to give you the judge. And now to really start the case and put them in the position, or put the case in a position where you can end it without their participation, you have to serve them. And what is service? Well, service is very similar to what you see in the movies. They get handed documents. The process server may or may not say you've been served. It's not a legal necessity that they say anything. So once they get served, and people try to avoid service sometimes. It's generally not going to work. There are avenues, there are things that process servers can do. They can't just throw their hands up and say, oh, you didn't hand it to me. The process server can still give it to them. If they don't want to pick it up, that's on the person getting served. If they're just locking themselves in the house and they're not opening the door for service, then you can actually file a motion in court and get permission to serve them via text message, FedEx, posting it on the door. The judge will let you serve it in a different sort of way. So once they've been served, then they have 30 days. They have 30 days to file their appearance. And appearance is what we just talked about. It's that legal document saying, I'm here, I'm participating in this case. And they also have to file what's called their answer. But for all intents and purposes, the appearance is really the most important thing to stop from being defaulted. So what happens if they don't file that appearance? What happens is that you or your attorney will file a motion for order on default, and that motion is basically saying to the court, We have filed the petition. We've served the other side. 30 days have passed. They haven't filed their appearance or the answer. So we want to end this case. We want to win this lawsuit without the participation of the other side. The judge will make sure that you've given them the proper notice, and the proper notice is going to depend on the judge usually, but service plus then sending them the notice via FedEx and email, if you have their email, is going to get the job done. And once the judge sees that they've had notice that they're not appearing, the judge will enter the order on default. At that point, you can go ahead and file a motion for entry of default judgment. And that default judgment and that motion is going to say to the judge, you have entered an order on default. The other side still hasn't appeared. We want to present this judgment for dissolution of marriage, which is the final document that the judge needs to sign. We want to present that to you for signature. You then will send that to the other side again to give them yet another opportunity to appear. And once you appear in front of the judge sees that you have crossed all these procedural bridges, that you've given the other side ample opportunity to appear. The judge will enter the default judgment for dissolution of marriage. The judge will sign it, and it does not need to be signed by you. It does not need to be signed by the other side. And at that point, you are divorced. Now, the biggest downside of the default divorce is that the other side could, within 30 days, file what's called a motion to vacate and try to convince the judge to open up the case again. And usually in a default situation, the judge will. So there is that downside of it, something to consider when you are thinking about whether or not a default or an agreed divorce makes the most sense in your situation. But those are the two most basic, simple divorce processes in Illinois. If you have any other questions, concerns, anything like that, drop a comment. Don't forget to subscribe, and I'll see you soon.